Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of pre-packaged insolvency resolution process under IBC. Even in the previous class also we have discussed pre-packaged insolvency resolution process. So half of the concepts we have discussed in the previous class. We will complete the remaining half of the part in this session. So in the previous class we have discussed about what is PR-IRP, what is pre-packaged insolvency resolution process, then who is eligible under PR-IRP, okay, then who can be appointed as a resolution professional. So while discussing the eligibility, we have discussed that MSME is eligible and the minimum triggering point, the minimum default amount must be minimum of 10 lakh rupees. Then who can be appointed as a resolution professional? We have discussed that any person who is eligible, he should be qualified resolution insolvency professional. So any qualified insolvency professional who is eligible to be appointed as an independent director, who is not a related party with the company, then in such cases, he can be appointed as a resolution professional. Then how to initiate the PR-IRP? So PR-IRP is initiated by the corporate debtor. Okay, so how to initiate we have discussed in the previous class. Then we have discussed about duties and powers of the resolution professional. Then formation of COC, how you are going to form the COC. Then procedures governing the meetings of the COC, we have discussed in the previous class. Now let us discuss about subsequent procedure to be followed. So once the COC is formed, okay, actually once the resolution professional is appointed, okay, so it is the responsibility of the resolution professional to appoint the register valuer. Why? Because once the resolution professional is appointed, okay, he is expected to give the information memorandum and he is expected to invite the resolution applicants. For all these things, he is expected to have the valuation of the corporate debtor, that is valuation of the company. So that's why if you observe regulation 38, which provides that the resolution professional shall within 3 days of his appointment appoint 2 register valuers to determine the fair value and liquidation value. So once the resolution professional is appointed under these regulations, within 3 days he is expected to appoint the 2 register valuers. Okay, these 2 register valuers are going to determine the fair value of the company, that is corporate debtor, and liquidation value. Okay, what is this fair value? We have discussed even in the previous classes also. Fair value means, in a simple language, in a layman language, if I want to say, fair value means if I am selling the assets, same assets of the corporate debtor in the open market, how much amount I am expected to receive. Okay, that is called as fair value, market value. Liquidation value means if I am closing down the company right now. Okay, so I am selling all the assets. So obviously valuation will be different. Okay, so as it is, if I am selling the assets, okay, that is called as liquidation value. So it is the responsibility of register valuer to determine the fair value and liquidation value. So accordingly, the resolution applicant, they are going to give the resolution plan. Okay, so unless they know the valuation of the company, they cannot give the resolution plan. Then, provided that the following person shall not be appointed as a register valuer, a related party. So if any register valuer, if any person is a related party of the CD or an auditor of the CD during the preceding 5 years, okay, in the preceding 5 financial years, if any person is an auditor or else if any person is a related party of the CD, then in such cases he cannot be appointed as a valuer. A partner or director of a insolvency professional entity of which the resolution professional is a partner or director. Okay, and if he is a relative of above, so if he is satisfying any one of these conditions, then in such cases he cannot be, or else if he satisfies, or if these above 3 conditions are triggered, then in such cases a person cannot be appointed as a register valuer. Okay, then as already we have discussed, once the register valuer is appointed, okay, he is expected to give the fair value and liquidation value. Okay, so which is provided under regulation 39. The register valuer appointed under regulation 38, valuers appointed under regulation 38 shall submit to the resolution professional an estimate of fair value and of the liquidation value computed in accordance with the internationally accepted valuation standards. Okay, after physical verification of the inventory and fixed assets of the corporator. So if you observe regulation 39, which clearly provides that the register valuers, because two valuers will be appointed, the register valuers, they are expected to give fair value as well as liquidation value. While calculating, they are expected to follow internationally accepted valuation standards. So in the previous classes we have discussed, and I have given you three generally followed standards. Okay, so I have explained you three standards. Okay, so one of them is the standards prescribed by the ICAI, and central government also prescribe the standards. Okay, so for the valuation, so you may follow any one of the standards according to your convenience. Okay, and one of the another important requirement is that whenever the register valuer is doing the valuation, it is the responsibility of the register valuer to do the physical verification of the inventory. So if register valuer is sending the authorized representatives or any representative to do the physical verification, then in such cases, such valuation is not a valid one. Okay, so in the previous classes, even we have discussed this with the help of judgments. Okay, in various judgments, NCLT held that, okay, if register valuer failed to do the physical verification, okay, the valuation given by him cannot be taken into consideration. Okay, so he is expected to do the physical verification. Okay, so physical verification of inventory and fixed assets of the corporator. Then information memorandum, regulation 40. So regulation 40 provides that, okay, you are expected to prepare the information memorandum. So what should be there in the information memorandum? So as per regulation 40, okay, so provides that the information memorandum should have assets and liabilities with such description as are generally necessary for ascertaining their values. So what is this such description? Okay, they have used the word such description. What is this such description? You are expected to give the value of assets and liabilities, that is book value. Apart from this, you are expected to give the cost of acquisition also. Okay, so when you are giving the cost of acquisition, then accordingly you can know, okay, so what is the cost of acquisition, what is the book value right now, is there any appreciation, is there any depreciation. Majority of the cases depreciation will be there in case of assets. In case of land, buildings, land, there is a possibility you can have the appreciation also. So what is the cost of acquisition and what is the value of the assets as per the book value. Okay, so these necessary details must be given to ascertaining their values actually. Okay, then you are expected to give the latest annual financial statements, then audited financial statements of the CD for the last 2 financial years. So last 2 financial years audited statements must be given by the in the information memorandum. Okay, then you are expected to give a list of claims, okay, containing the names of the creditors, then amount of their claims. Okay, so list of creditors, against to them amount of claims, and if any security interest is there, that means whether the company has created any security in favor of the creditor. Okay, so such details must be given. Then particulars of the debts due from or to the corporator with respect to related parties. So whether related party has borrowed any funds from the company, then the details about such borrowings. Whether the company, whether related parties gave any loan to the company, that is creditors, you have to give the details. Okay, along with the interest rate and other terms and conditions. Then regulation 40 provides that, okay, it is a continuation. Regulation 40 provides that details of guarantees that have been given in relation to the debts of the corporator by other persons, specifying which of the guarantors is a related party. So whether any guarantee is given, okay, so whether company borrowed any funds, for that any related party gave the guarantee, he may not be related party, he may be some third party. Okay, so whether any third party gave the guarantee, okay, so for that debt you have to give the details. Okay, then the names and address of the members or partners holding at least 1% of the stake in the company. Okay, so when you are preparing the list of shareholders, okay, so in the list of shareholders you are expected to give the highlight the address and names of the members or partners. Okay, in case of LLP, partners will be there. So who is having at least 1% of the stake, you are expected to give the details in detail. Then details of all material litigation, because the litigations are going to impact the company. Okay, suppose if you fail to, or in the litigation if you lose the case, then in such cases you may end up in paying the huge damages. Okay, so that's why the details of all material litigation and ongoing investigation, okay, or any proceedings are there initiated by the government or statutory authorities. Okay, so maybe because you are an MSME, maybe pollution authorities might have started one investigation process, then you have to disclose it. Maybe labor department have started, or factory inspector, like that. Any government authorities, if they have initiated any proceedings against the corporate debtor, such proceedings must be disclosed in the information memorandum. Then the number of workers and employees and liabilities of corporate debtor towards them. So how many workers are there, how many employees are there, whether any salary is due. Okay, so do you have any salaries due, so how much amount is due, so this information must be given. Then other information which the corporate debtor or resolution professional deem fit. Okay, so for the purpose of the resolution process, okay, whatever is deemed fit, such information can be given in the information memorandum. Let us look at the other important provisions. Okay, Regulation 41 provides that on or before 30th day of pre-packaged in commencement date, PR-IRP commencement date, the resolution professional shall form an opinion whether corporate debtor has been subject to any preferential transactions. So as already we have discussed in the previous class also, the resolution professional is expected to receive the claims from the creditors. Once if he receives the claims, these claims must be collected and collated. We have discussed the significance of collected and collated in the previous lessons. It must be collected and collated by the resolution professional. Then subsequent to that, okay, he has to form an opinion whether any transaction is in the nature of preferential transaction. Okay, so in the subsequent lessons you are going to discuss about PUEF transactions. Okay, so preferential transaction, undervalue transaction, extortionate transactions, fraudulent transactions, like that various transactions are there, okay, which are considered to be avoidance transactions. Okay, so do you have any preferential transactions? Because if we are having any preferential transaction, then such transactions must be excluded and you have to recover the money, okay, that is paid through the transaction. Okay, so you have to form an opinion as to whether corporate debtor has any preferential transaction in their balance sheet. Then the CD shall submit the base resolution plan. So one of the unique nature of this PPIRP is that CD is going to submit the base resolution. So this base resolution concept is not there in the normal regular CRP process. Okay, so the CD shall submit the base resolution plan to the resolution professional within 2 days, because he is a person who is initiating. So once the resolution professional is appointed, within 2 days of the pre-packaged insolvency commencement date, okay, the CD is going to submit the base resolution plan to the resolution professional. Okay, then and the resolution professional shall present it to the committee of the creditors. So once if he receives the base resolution, then it has to be placed before the committee of the creditors. Okay, then the committee of the creditors may approve the base resolution, possibility is there. Okay, so and it may go for submission to the adjudicating authority. Okay, then the RP shall publish brief particulars of the invitation. Okay, another important provision is that the RP shall publish brief particulars of the invitation for the resolution plans in form number P11. As already we have discussed, all the forms in these regulations are like P1, P2, P3. Okay, so P11 not later than 21 days from the pre-packaged insolvency commencement date. So the RP is expected to publish the resolution plans. Okay, then what should be there in the resolution plan? So please remember, the contents of the resolution plan similar to the contents of the regular resolution plan under the CRP process. Okay, so anyway, so let us discuss the contents of the resolution plan here. Regulation 44 of the PPIRP regulations, which provides for the contents of the resolution plan. The resolution plan shall contain the following data. Okay, so which includes transfer of all or part of the assets of the corporate debtor to one or more persons. So are you transferring any assets that belongs to the corporate debtor to other person? Please state. Sale of all or any part of the assets, whether subject to any security interest or not. So are you going to sell any assets? Maybe there is a possibility such assets may be subject to charge or may not be subject to charge. Okay. Then restructuring of corporate debtor by way of merger, amalgamation, demerger. So this concept already we have discussed in detail even in the previous lessons also. Your resolution plan may contain restructuring of the corporate debtor also, like in the nature of merger, amalgamation. So now the question mark arises whether in case of merger, amalgamation or demerger, etc., are you expected to follow procedure under the Companies Act also? Because you are having section from section 230 to 240 of the Companies Act, which provides for the arrangements. Various sections are there relating to that. So whether are you expected to follow the Companies Act? In the previous lessons we have discussed that prima facie you are expected to follow IBC. Okay, first comply with the IBC provisions. In addition to that, okay, so if it is not contradictory to the IBC provisions, you are expected to follow the procedures even under the Companies Act also. Okay, then the resolution plan may contain substantial acquisition of shares. So someone may say that we are going to acquire the company, substantial acquisition. Okay, then cancellation or delisting of any shares of the corporate. So there is a possibility you can cancel or you can go for delisting of the shares also if applicable. Okay, then what are the other contents? Satisfaction or modification of any security interest. Maybe one of the lending institution, they have given the loan and they have already taken the charge. Okay, so now through the resolution plan you are satisfying or modifying the security interest. Then in such cases even these things can be a part of the resolution plan. Okay, then curing or waiving of any breach of the terms of any debt due from the corporate debtor. So there is a possibility you can waive off. Okay, so there is a breach is there by the corporate debtor. Okay, so but you are curing or you are waiving the breaches. Okay, so that is also possible. Then reduction in the amount payable to the creditor. So generally majority of the cases this clause will be there, as already we have discussed even in the previous lessons also. Okay, whenever you are proposing the resolution plan, I can say 80 to 90% of the cases reduction in the amount payable to the creditors will be there. So this is also called as haircut, because the amount that is payable to the creditors is reduced. So that's why we'll call it as a haircut. So majority of the cases nowadays we are having haircuts. So is it a good plan, good scene or not? That is a different issue. Okay, haircuts are there in the resolution plan, proposed resolution plan. Okay, but one ideology is that when you are accepting the lesser amount, maybe in the short run that is not beneficial to the financial creditor, but in the long run, or if you look at the economy as a whole, okay, this money again, whatever he is recovering from the corporate debtor, this money again this financial creditor can invest somewhere else. That is reinvestment is also possible. So that's why it is going to, instead of keeping the resources ideally, okay, if you can recover with some deductions, if you can recover, such amount can be reinvested somewhere. So it is going to help the economy as a whole. Okay, so this is the ideology behind accepting the reduction in the amount payable to the creditor. Okay, then extension of maturity date. So if any maturity date is there, then you can extend or change in the interest rate. Possibility is there, even you can change the interest rate also. Okay, then amendment of the constitutional documents of the corporator. So there is a possibility even as a part of the resolution plan you can amend the constitutional documents also. So what is constitutional documents? Your memorandum of association, articles of association. Okay, so these considered to be constitutional documents. So as and when it is required, maybe you can propose the amendments to the constitutional documents also. Like you may propose the alteration in the objective clause of the company. Okay, so alteration in the capital clause of the company, like that various alteration can be proposed depending on circumstances. Then issuance of securities of a corporate debtor for cash, property, securities or in exchange for claims or interest or other appropriate purpose. There is a possibility you can convert the debt into equity. So existing debt, for the existing debt you can issue the securities. Even that is also possible. That means you are doing the debt restructuring. Okay. Then change in portfolio of goods or services produced or rendered by the corporate debtor. So you can change the portfolio of goods and services. So previously, maybe take the example, you are rendering the services and also you are selling the goods. The revenue from this goods and services both are 50-50%. Now you wanted to concentrate more on services, then you can increase the share of the services. Okay, so you can increase the your manpower, etc., in provision of the services. Okay, even that is also possible. And as a part of the resolution plan, sometimes even you can propose the technological changes also. Maybe the existing corporate technology is very outdated. Then in such cases, you can propose the technological changes also. Okay. Then obtaining necessary approvals from the central government and state government, other authorities. But here, as already we have discussed, you have to be very careful. Resolution plan, when you are proposing, you are expected to get the approval from the central government and other authorities. So this approval process has to be completed within a period of 1 year. Okay, so once the resolution plan is started, approved, from that date onwards, within a period of 1 year, you are expected to get the approval from the central government and other authorities. But when it comes to the Competition Act, okay, so under the Competition Act, Competition Commission of India is authority. So in such cases, okay, if the approval is required from the CCA, the approval from the CCA has to be obtained in advance. That means before placing it before the COC. First you have to get the approval from the CCA. Then subsequent to that, you can place the resolution plan before the COC. Then you can approve it. Okay, so the CCA approval is in advance. Okay, so remaining you can take it later. Then let us look at the mandatory contents. Okay, till now we have discussed the regular general contents. Now let us look at the mandatory contents. In the mandatory contents of the resolution plan, the term of the plan and its implementation schedule, and management and control of the business. Okay, then resolution plan shall demonstrate, okay, how it is going to address the cause of default, then feasibility and viability. Then it has a provision for effective implementation. Do you have the provisions for effective implementation or not? It has provisions for approvals required and the timeline for the same. So these things must be included. Okay, then the resolution applicant has a capability to implement it or not. So these things must be considered when you are preparing the contents. Okay, these are all mandatory consents. Then let us look at the other important provisions. Okay, so regulation 46 provides for the submission of resolution plan. So once that is approved, you are going to submit it to the adjudicating authority. Section 54K, okay, which speaks about presentation of resolution plan by the resolution professional to the COC. So once the resolution plans are received from the prospective resolution applicants, then in such cases, after that the resolution professional is expected to submit or present it before the COC, Committee of the Creditors. Okay. Then Regulation 47 provides that the resolution plan received under Regulation 46, which comply with the requirements of the code and these regulations, shall be evaluated based on the evaluation. So in the previous classes, even we have discussed about the evaluation matrix also. So you are going to develop the evaluation matrix. So based on the evaluation matrix, the COC is going to review it. Okay. Then the resolution plan which gets the highest score in the evaluation matrix, if any resolution plan gets the highest score, then it shall be selected for the competition with the base resolution plan. So then as already we know, under this PR-IRP you are going to submit the base resolution plan also. So this resolution plan submitted by the third party and the base resolution plan will be competing with each other. Accordingly you are going to decide what to do. Okay. Then Regulation 49, if you observe, which provides for application to the adjudicating authority seeking approval from the resolution plan. So once the COC approves the resolution plan, then you are going to make an application to the adjudicating authority, that is NCLT. Then NCLT is going to either approve the resolution plan or else they may reject it. Okay. So section 54L provides that if the adjudicating authority satisfies that the resolution plan as approved by the Committee of the Creditors, and please remember, when they are approving the resolution plan, they are not supposed to question the commercial wisdom of the Committee of the Creditors. Okay, so it is only whether did they follow the procedure or not. These things NCLT can verify, but they cannot verify the commercial wisdom. Okay. Then if you observe section 54N, okay, which speaks about termination of prepackaged insolvency resolution process. Okay, so we are having provisions relating to termination. Then appeal against the order. So if you want to go for an appeal, yes, you can go to the appeal, okay, before the NCLT. Then let us look at the initiation of CRP. So section 54O. Okay, so who can initiate? The Committee of the Creditors at any point of time after the PR-IRP commencement date, but before the approval of the resolution plan. Okay, so by vote not less than 66%, they can initiate the CRP. So that means now PPIRP is going on. Once the PPIRP is going on, generally PPIRP will continue and you are going to close the issue in PPIRP only. But there's a possibility committee of the creditors are of the opinion that PPIRP is not possible or it is not viable. Then in such cases, they can initiate the CRP. But please remember, for this, you are expected to get the majority with 66%. Okay, so then you can withdraw from the PPIRP, then you can go ahead with the regular CRP process. So with this, we have completed. Okay, so once the CRP process is done, then again regular procedure will continue. Okay, so with this we have completed the concept of PPIRP. Let us rewind, let us recap what we have discussed till now. So in this lesson we have discussed about appointment of registered valuer. So once the resolution professional is appointed, he is expected to appoint the 2 registered valuers. Then we have discussed he is expected to give the fair value and liquidation value. Okay, then we have discussed the meaning of fair value and liquidation value. Then subsequently the resolution professional is expected to go for information memorandum. Okay, then we have discussed the contents of resolution plan and mandatory contents of the resolution plan. Okay, then once the contents are there, then we'll go for submission of resolution plan. So once that is submitted, it is to be approved by the resolution plan. Okay, so it is to be approved, the resolution plan must be approved. Okay, then once it is approved by the COC, okay, so resolution professional is going to place the resolution plan before the COC. COC is going to approve it. Then subsequent to that, you are expected to make an application to the adjudicating authority. Okay, then adjudicating authority may accept it, may reject it. Okay, so if any grievances are there, then you can go for an appeal under the legislation. Okay, then if there is a failure, that means you are of the opinion that PPIRP cannot be continued, then COC with 66% of the voting, okay, they may make an application for initiation of CRP where they are of the opinion that so we cannot go under the PPIRP process. Okay, then in such cases you can go for initiation of CRP. Then regular CRP process will start. Then again other things will happen as we have discussed previously. Okay, thank you.